Well, welcome everybody to our third week of our AFRL New Mexico Tech Engagement Office webinar series on intellectual property. Today's topic is the patent process. My name is Matt O'Brien, Program Manager for the AFRL Tech Engagement Office. On our call today, we have Anna Kutala, an IP lead and patent agent with our office. We also have David Narciso, patent attorney with AFRL headquarters out at Wright-Patterson Air Force Base. And as always, we have Dr. Gary DeBoer, who will be leading the discussion today. Go ahead and take it away, Gary.
Hey, thank you, Matthew. Just like to review a little bit from last few weeks where we've been. We've talked about why we might want to patent. And we also talked last week about what is patentable material. Today, we want to talk about the application process. Next week, we will talk about how to engage with the Tech Engagement Office if you think you have a patentable idea. So today, we'll talk about the types of patents and the types of patent applications. We'll talk about the parts of a patent publication. We'll talk about how filing dates and the life of a patent are related. We'll talk about the timeline of the examination process and the flow of the examination process. Let's begin by reviewing what a patent is. A patent is a provisional right that allows you to exclude others from making, using, offering for sale, or selling the invention throughout the United States, or importing the invention into the United States. And if the invention is a process, a patent gives you the right to exclude others from doing much the same with products made by that process. So a patent is a right to exclude others. We talked about the three types of patents. The utility patent, which is for processes, machines, manufactured items, and compositions of matter. We talked about design patents, which are for ornamental designs, how something looks, and plant patents, which are for things like roses. Today, we want to talk more about the types of patent applications that will hopefully lead us to these three types of patents. And the first type of patent application we want to talk about is called the provisional. And note that this provisional is colored red to match the red of the utility patent, because you can only have provisional applications for utility patents. No provisionals for design or plants. And a provisional is a temporary application. It allows you to do some things as you get together stuff and formalize what you're doing and explore markets and investors so that you can eventually apply for the non-provisional application. And this must be done within 12 months of the provisional. The provisional isn't examined, it just goes away after 12 months unless you follow up with this non-provisional application. Now, you don't have to have a provisional application. You can start with a non-provisional application. For design and plant patents, you must start with a non-provisional, and you hope that these non-provisional applications will lead you to an issued patent, utility design or plant patent. But life isn't always so straightforward. There may be a time when the examiner looks at your non-provisional application and says, hey, you have more than one invention in this application, and we can only give you a patent for one invention. So you better choose which one you want in this application and then put the other inventions in another application. And that application we would call a divisional of the parent non-provisional application. So you would file your divisional application currently with the non-provisional application, and both of these applications, or more if you have more than two inventions, would be all pending concurrently in front of the examiner, hopefully eventually becoming an issued utility patent for each of these different types of inventions. So that's all good. But things can also get more complicated if during this examination process the examiner says no to you, not once but twice, and you only get two chances. And if you give up after that second chance, your application would become abandoned and you would never get a patent on that invention. But you can, however, get a continuation to the examination by requesting a continuing examination if it's a utility application, or you can file a continuing prosecution application if it's a design application. So designs and utility patent applications can be continued after that first round of things there, and hopefully with that continuing application you can then get your stuff issued as a patent. Note there's no continuing application for plant patents, so hopefully you know what you're doing if you do a plant application. You get it done the first time. Now, here's a survey question for you. Which statement or statements is or are true with respect to a provisional patent application? And Noah, can you load that survey question for our audience now?
Yep, it is going now. So
Great.
everybody is free to answer, including panelists and attendees.
Great. Yeah.
And a reminder, it is multiple choice, so click as many as you think are correct.
Yes. Thanks, Noah. So, which is true of a provisional patent application? Can it be used for design patents? Is it examined or not examined? Will it become abandoned after 12 months? And must it be followed up with a request for a continued examination? Enter your answers now. We'll give you a few more seconds there, or maybe a lot more seconds if we don't have people participating. Okay, do we have some answers in there, Mr. Noah?
Yeah, we have one in, and Stanley also answered through the question and answer section.
Oh, okay.
I don't know if you're unable to answer to the polls there, but you should be able to answer to the polls there, Stanley. But his answer was A and D.
Mm-hmm.
And then the other answer that we also got in is D.
Okay. Well, let's look at the correct answers here. The correct answers are B and C. A provisional patent application is not examined, and it will become abandoned after 12 months. Don't confuse the request for continued examination with the non-provisional application, which must follow up the provisional patent application. And there is no provisional patent application for design patents. Those all must be non-provisional applications for a design patent. All right, well, let's move on here and talk about the things that you as an inventor will want to put into your patent application by looking at the parts of a published patent. And you can find published patents on the uspto.gov site by searching up patents under the PAT-FT, or you can find published patent applications by searching things up under the app-FT functions there. So here's a patent publication that I found using one of these engines, and we can look at all the different parts of this published application. The first part you want to look at is what we call the front page, and this front page spills over to the second page, so you might call it the front pages. The next part of a patent are the drawings, and this one has 6 or 7 pages of drawings in it. The next part is what we call the written description that goes with this thing. And the fourth part of the published patent is the claims. So let's look at each one of these pieces and glean from them some things that you as an inventor should pay attention to as you look at patents, and think about how you might write up your invention disclosure for a patent publication. Let's begin by the front page. One thing you'll notice on the front page is that it lists the inventors. It also lists things called applicants and assignees. The applicants are usually the same as the inventors, but sometimes the owner, the assignee, can also be the applicant. And the assignee is the person who owns the IP rights. So in this case, the U.S. Air Force here owns the rights to this patent. Another thing you'll see on the front page is what we call the CPC codes. And these are very helpful. If you find a patent related to your invention, you can then search the uspto.gov site for more inventions related under this coding. So this allows types of things to be coded under these different classification schemes. Another thing you'll see on the front page are references. The ones with stars are the references of the examiner. Ones without stars are the references put in there by the inventors. A's are for published applications, or B are for published patents. And those can be very helpful to you if you want to look at other things related to this particular patent that you found. You also see on the front page an abstract. And the abstract, like in a journal abstract, is supposed to give you an idea of what this invention is all about. And the last thing you'll see on the front page is some representative drawing. That kind of shows you how the invention works, which is what the purpose of drawings is, to tell you how the invention works. So let's talk more about drawings here. Here you can see on the left figure 1, and over on the right figure 1b and 1c, and this shows how this particular invention works. You have this deployed mode in which this invention expands out and takes up more volume, and you have a stowed mode of this invention in which the invention takes up less space and is good for, volumes that are less. So this allows this thing to possibly be launched up into space using a small volume and then deployed out into space where it can take up a larger space. And so figures such as this help the person looking at the patent understand more quickly what the patent is all about. Now, following the drawings, you'll see a written description, and there's lots of parts to the written description. You'll see some comment about the government interest, and the government has an interest in this patent. You'll see a little section on the field of the invention, and that'll be related to those CPC codes as well. Then you'll see a background section. And the background section you might think of as the problem. This is where you state what the problem is. And then the next section, the summary of the invention, now is your solution, your inventive concept that is the solution to that problem. The next part you'll see in the written description is a brief description of the drawings. Remember, the drawings are supposed to explain how the invention works, and this brief description of the drawings helps to use in words explain what the drawings are supposed to convey to the reader with respect to how this invention works. After that, you'll see a more detailed description of the invention, and this will get into the nuts and bolts, literally, of how the invention goes together. So, for example, here you can see in this detailed description, this paragraph or two describes in more detail exactly how this invention is all put together and how things are all connected with each other. And then the last part of our patent publication is the claims. And you can think of claims as staking out your intellectual property, very much like you stake out your realty type of property. You pound a stake in the ground and you say, this is my property from here to here and there to there, and this is mine and I can exclude you from using my property. The same here with the claims. where stating what the inventor says is his and wants to exclude others from using. So if we look at the first claim here, we can see that the claim starts out with this little preamble, a tubular structure configured to, okay? And then it has this transition word, comprising, and that tells you what it is made of, and it lists then some of these elements of the invention. This double helix and these rings that are connected to that double helix. But it's not enough just to list the parts. You have to list how these parts relate to each other to do what the invention is supposed to be doing. So this first claim is an independent claim. We say it stands all by itself. It doesn't reference any other claim. But if we look at the next claim, the second claim, it's much shorter, but it references claim number 1. So we say that claim number 2 is a dependent claim. It depends on all that stuff that was listed in claim number 1, and then it adds some more limitations, as we say, to what's going on here in this invention. So claim number 1 was an independent claim. Claim number 2 is a dependent claim. You can also have what we call multi-dependent claims, and there aren't any in this particular patent publication, and U.S. patents don't typically have them. But in a multi-dependent claim, claim number 3 might reference both claim number 1 or claim number 2. So 3 types of claims: independent, dependent, and multi-dependent claims. Now, for scientists out there, you might start thinking to yourself, hey, this stuff in a published patent is similar in many ways to my research publication. In a research publication, you're going to have a part that lists the authors, the abstract, and the references. You're going to have figures that are similar to drawings. Then you're going to have a body of your paper that usually has the IMRAD approach to things: an introduction, a method, results, and discussion. These all kind of match up with the written description part of a patent publication. And then at the end of your paper, you're going to have conclusions where you claim what you've contributed to the cause of science. Likewise, in a patent, you have a claim to what you say is your inventive step that you contributed to society here. Now, there's one thing you should note here with respect to inventors and authors. In a research publication, quite often a number of authors are listed, and everybody who's in the lab gets their name on the paper, and anybody who took a spectrum or contributed something gets their name on the paper, and lots of people then can become authors on a scientific paper. In a patent application, the inventors have to be the actual inventors. And technicians or people who just did something for the inventors at their direction don't count as inventors. The inventors here have to actually have invented something that's listed here in this patent publication. So you might ask, can you patent and publish? Yes, you can patent and publish, but it's better to patent first and publish second, because if you publish first, you may put up a bar, you may stop the possibility of you being able to obtain a patent on the same material. But as you write up your patent application, you keep in mind the parts that you would want to put in for a journal publication, and that's a good idea to kind of do it that way. So this brings us to survey question number 2 to see if you guys have been paying attention. Noah, can you load survey number 2?
Yep, it is up now and free to answer for everybody.
Great. So inventorship on a patent application is very similar to authorship on a scientific research publication. True or false? I'll give you a little time to think on this and enter your answers. Hoping that you're enjoying your lunch at this hour while watching this webinar. Okay, well, let's give you a few more seconds here. 5, 4, 3, 2, 1. All right, Noah, do we have some results of our survey?
Yep, looking at the results, we have a nice lead by false, with false ahead by 67%, with true getting 33% of the votes.
Great. Excellent. Yeah. And the correct answer is false. Here, authorship on a scientific publication is little bit similar. It certainly is not very similar to the inventorship on a patent application. Inventorship on a patent application has to be the inventors, where authorship on a scientific publication oftentimes is a whole bunch of people who maybe contributed very little to the actual writing or idea that was part of that research publication. All right, now let's talk a little bit about the filing of your patent application and how that influences the life of your patent. So the life of a patent is based on the filing date of your non-provisional application. And the life is 20 years from the filing date of that non-provisional application. So if you file your application on May 21 of 2020, 20 years from that date will be May 21, 2040, assuming that you pay the maintenance fees along the way. Now, you know that you also could have, instead of filing a non-provisional, you could have filed a provisional application. And if you had filed a provisional application on May 21, 2020, you would have had to follow up with the non-provisional application within a year of filing that provisional. Now, if your patent issues in about the same time period there of 3 years, so a total of 4 years from when you filed your provisional to when your patent issues, the patent life is still determined by 20 years from the filing date of the non-provisional. So that brings you out to May 21, 2041 versus May 21, 2040 if your first filing had been a non-provisional. So this is one reason you may want to file a provisional application, because it gives your patent an extra year of protection. If I can get that to come, hang on here just a second. There we go. So you have protection on your invention from the filing date of the first application, which in this case is a provisional, and the life of the patent is determined from the filing of the non-provisional. So you actually get 21 years of patent protection by filing that provisional first. Another reason you might want to file provisional is that during this year in which you are putting together the non-provisional application, you can research the market, you can look for investors, and you can ask yourself, do I really want to file this non-provisional? It's going to cost me a lot of dollars. Yes, maybe I'll just cut my losses and forget this one. All right. So, filing a provisional can add a year to the life of your patent. And there you go. Now, let's focus in a little bit more on the pendency period of your application from when you file it to when it issues as a patent. And let's look at what happens during this time. Okay, so you file your application on May 21, 2020. The examiner then has a long time, 14 months, according to the rules, to look at your application and send you his response, the examiner's first response. So you sit there and wait. Now, once you receive the examiner's response, which will probably be a rejection because very few allowances happen on the first examiner response, you will have 3 months to reply to the examiner. Then the examiner will have 4 months to reply to your response, and then you will have 3 months to reply to the examiner's second response. The examiner will have 4 months to reply to your second response, and you can see how this is kind of going. Hopefully on the second response, you get a positive affirmation from the examiner, and he will issue you an allowance. If he does, you will have 3 months then to pay your issue fee, and the USPTO will have 4 months then to issue your patent. If you don't get an allowance here, you're going to have to request a continued examination if it's a utility patent application, or start over again there. So overall, if you add up all these numbers, I get 35 months. And so the USPTO has guaranteed that you will, if you do all your part properly, get your patent issued within 3 years if it's a patentable sort of thing. Now, what happens if it takes them longer than 3 years to issue your patent? Let's say it takes 4 years to issue the patent rather than 3 years. Well, you don't get your money back with this guarantee, but what they do is they add the time that went over the 3 years to the end of the life of the patent. So if you went over 6 months, you'd add 6 months to the end of your life of your patent, and 1 year you'd add 1 year, and so forth and so on. And so this is the guarantee that the USPTO gives to you in an effort to try to get all this stuff timely issued, if it's a good patent. All right. So, given that, here's survey question number 3. Let's say you have a non-provisional utility application that's filed on July 29 of 2018, and the patent issues on July 25, 2020. When will the patent expire? All right, Noah, can you load up the survey there?
Yep, I just launched it now, so everybody is free to answer.
Great. So again, you filed this patent on July 29, 2018. It issued July 25, 2020. Will it expire on July 29, 2033? July 25, 2035? July 29, 2038? Or July 25, 2040? One correct answer here. So see if you can choose the correct answer to determine the life of this patent. So I'll give you a few more seconds here as we wait for responses to come in. Again, the patent application is filed July 29, 2018. It issues July 25, 2020. When will the patent expire? July 29, 2033, July 25, 2035, July 29, 2038, or July 25, 2040. Do we have some answers in, Mr. Noah?
Yes, sir. I'm about to end the polling now. Okay, and now it just finished. We have a closer one here. We have 2 votes for July 29th, 2038, and 1 vote for July 25th, 2040.
Okay, well, let's look at the answer here, and the answer is July 29, 2038. 40 years from the filing date of the non-provisional. And this is a non-provisional utility application. No provisional is involved. So we have that information, July 29, 2018. Add 20 years, and you get to 2038. The thing that you would maybe want to check is, did the patent issue within that 3-year guarantee? And here we see that, yeah, the patent did issue within that 3-year time period, so there wouldn't be any extension to that life of that patent. So all looks good here for the standard 20 years from filing for the life of our patent. Right. Let's talk about the flow of the examination process. And this is a little flow chart I took from some law firm website someplace. And these are the sort of the steps that they have with respect to how the application process would flow. You'd start with a patent search, and you do this before you come up with your patent application to see if your invention is unique. Is it novel? Has it already been patented, or is it out there in the public? So it says optional, but that's a really good idea to do a patent search before things get too involved here with respect to money and time and everything else. And because this came from a law firm, they want to get your money. You guys work for the AFRL, so hey, you don't have to worry about this step. The next step then would be for your attorneys and agents to prepare and file that patent application. At the time of filing, you will have a patent that is pending. You'll wait to hear from the examiner, and you'll be responding to the examiner's comments in this little cycle that we saw earlier. And you hope then at the end that the examiner will issue your patent. If he doesn't, you could try to appeal to what we call the Patent Trial and Appeal Board, or you might just give up and abandon. Over here you can see these other options, these continuing type of applications that we talked a little bit about before, and divisionals. They might come into play too in the flow of how your patent proceeds here. Now, this is a pretty simple diagram. On this next page here, if I can get it to load, here we go, is a little bit more of a complicated diagram, but the idea is still the same. You got the searching here, up there, where they talk about a patent search. You got what in this diagram is called the drafting, where it has a client review in there and all this kind of stuff. We might call this preparation of the patent application. And then the patent is filed with the office, and then it's now pending before the USPTO. And we have all these different channels that things could go. You'll see that if you follow the flow of the little arrows here, it goes from here. You wait for the USPTO office action. It could be a rejection or allowance or restriction. Restriction relates to those divisional applications we were talking about a little bit before. If it's a rejection, you'll study that office action. You'll come up with some options, choose an option, and then you'll go back through this little cycle there again. If you get an allowance, lucky you, then you pay your issue fee and you'll get your patent issued there. You might also, in choosing your options, go through an interview route where you can talk to the examiner and maybe explain to him a little bit better what you meant by your invention. Maybe he didn't quite get it, and if you can demonstrate to him through an interview what this is all about, maybe his lights will go on, and that might help your case. And of course, if you get a rejection, you might also appeal to the Patent Trial and Appeal Board if it's a final rejection. And that might also lead to a grant of your patent in this process. So the point of this more complicated flow chart is to let you know that there are many paths to getting an issued patent, and not every application takes the same path. So let's review what we've talked about here with respect to the patent application. We talked about types of patents, utility, design, and plant. We talked about types of patent applications, the provisional, the non-provisional, the divisionals, the continuing. We talked about the parts of a patent publication, which you should keep in mind as you work with your attorneys and agents on your invention disclosures. Those parts being the background, which is the problem, the summary of the invention, which is your solution, the drawings, which show how the invention works, and then the detailed description of how all these things go together, and finally the claims, which you are claiming as your invention. We talked about how the filing date of the non-provisional application determines the life of a patent. We talked a little bit about the timeline of the examination process and how this can take a long time to go from application to issued patent. And we talked about the different paths that your application may take on its path from application to issued patent. So if you have a patentable idea, you think, and you want to get started on this process, the person to talk to here is Anna Kutila. And you can reach her at Anna at AFRLNewMexico.com, or you can use her us.af.mil address if you like. She also has a phone number, 505-846-1897. And with that, I'll turn it back over to Matthew O'Brien to field any questions or comments that might be out there in the audience.
Thanks, Gary. So for all of our attendees, if you do have questions about anything that was talked to you today, presented today, myself, Anna, David Narciso, and Dr. DeBoer will answer any questions. So go ahead and use the Q&A function on your Zoom, and Noah will help us get those questions answered.
Okay, well, people are starting to ask questions. We do have a question that was asked quite earlier in the webinar by Stanley. He had a question saying, why isn't background called problem and summary called the solution?
I don't know. These are suggested sort of parts. Yeah. Oh, David might want to better answer this. Yeah, go ahead, David.
I can. You want to be careful in this. The background is probably the best way to call that introductory section, because, you know, in some cases people called it prior art, and then the examiners would say, well, that's admitted prior art, when in fact often in the background section there will be a discussion of what the existing technology is, and a statement regarding a problem that was seen with it. That problem, recognition of the problem, is sometimes key to the invention, and that, you know, where somebody didn't recognize what the problem was, once they understood the problem, the solution could become very obvious. And so recognition of a problem is considered and can be argued as part of the invention. So it's best to call it just background, and that way it genericizes the discussion of the technology.
Mm-hmm. Yeah, it's not required that you call these sections the names that they give them, but it is required that you have the content in there. And so these different names for these different parts of the patent have sort of developed over time this way.
Okay, so we have another question here by Stanley. He's just wondering where that he can get a copy of these slides in the presentation.
Oh, Matthew, you're probably the best person to know here. I can send them to you, and how best can you distribute them to your people?
That sounds great. Yeah, Stan, happy to send you copies of the slides. All the presentations are being recorded as well, and we can share links to the past presentations as well.
Okay, so we have a couple other coming in. We have Gabe. It's not a good question, but he just wanted to say thanks for the info and that it was a great presentation today.
All right. Well, we thank Gabriel for that.
And then we also have another one from Stanley. It's also not a question, but it's also saying thank you for your time and the info, and that today was very useful for him.
Great. That's our hope here, that we can be of some use to the inventors out there.
I'm going to give a bit for a couple more questions to roll in.
Mm-hmm.
Okay, so Stanley has another question. Who can provide assistance with figures?
If you're talking about in preparation of the patent application, we have a draftsman. I'm not sure how we operate it down at Kirtland. I'm operating out of Bright Pat right now. That we will work with the inventors to develop what those figures should be to describe the invention, and then the patent draftsman can do that, because it's kind of a particular area in art of how you put these figures together. But inventors can help a lot if they can give us some, their best shots at what the invention is. And then the patent attorney will work with the inventors and with the draftsman to come up with appropriate figures for the patent application itself.
Okay, so that looks like it is all the questions for now. Oh, we actually do have another one. So Stanley is wondering who does the drawings here locally in ABQ or at the Kirtland Air Force Base?
Hey Stan, so this is Matt O'Brien. We do not have our own draftsman here in Albuquerque, so we rely on the support from Right Path.
And again, if the inventors can, just come up with the best sketches possible that they can, we can go from there to work on getting appropriate drawings put together. Again, drafting of the patent application is something that the patent attorney will do. I guess we should clarify that next week. There will be discussion on the actual disclosure process, what the inventor side would do, because you cannot, obviously you're not going to draft the actual application. There's a lot of nuances about how to draft an application, how to draft claims, and that is up to a patent attorney to deal with and to create that document for ultimately filing with the U.S. Patent Office. And I could mention that there was a discussion of the provisional patent application process. Provisional could include almost anything, but it's only as good and can only be relied on for the content of that provisional application for the priority for that ultimately non-provisional filing. So there's different ways that provisionals can be prepared. Sometimes they're essentially the paper that's about to be published in order to preserve the dates, and with maybe some work by the patent attorney. In other cases, a full-up patent application could be prepared, and then at the time of the non-provisional filing, it would need to be updated, because the non-provisional, the requirements are that the invention should be described, including the best mode at the time of the filing date. And so if the application or the invention has been further developed, you'd want to update the attorney to make sure the description and claims reflect the invention as of the filing date of the non-provisional patent application.
I'll give a minute or two just in case if somebody else has another question to answer, but right now we do not have any questions in that are not answered.
Yeah, for many people, a provisional is good because it's very cheap to file, and maybe the Air Force is less concerned with that. Maybe they want to go right away to the non-provisional. So it might depend where you are and what your plans are for this technology, whether you file the provisional or the non-provisional. And that's something to think about as well.
Okay, well, if there's no more questions, thank you everybody for joining us today. We hope you can join us next week, next Wednesday at noon Mountain Time for our fourth and final presentation. So that's August 5th at noon Mountain Time. Thank you, everybody.